All right. Thank you, everybody, for being here on this sunny Thursday afternoon. We've got about an hour today, and we're going to talk about some of the drafting details about the manner of bringing an appeal from the Justice and Municipal Courts to the Circuit Courts. Last time we talked about the timeframes for bringing those appeals, and then today we're going to focus on the notices of appeal, specifically what needs to be in those notices and what the contents of the notice and who needs to be served with it. And we'll be zeroing in on the sections of the draft bill that Jessica and Jim have prepared relating to those topics. And then at the end, I would like to just identify some possible components of our work that people might be able to volunteer to help with. A research project, thinking about how we're going to do our outreach to the other stakeholders who are involved in this, perhaps through a survey. So that'll be at the end, but we're just going to talk about the bill sections relating to notices of appeal. We'll continue that. I do want to, for those of you who've been on the call, we were talking about the numbers. So Melissa, thank you for getting those numbers for us.
And Justice Duncan, just really quick, it looks like Kaiti has joined us.
Oh, great.
All the thanks to Kaiti for doing that.
All right. Kaiti, thank you for preparing those numbers and sending those to us. They're very helpful in giving us an understanding about what types of appeals we're getting, what numbers of appeals we have. That'll be a great baseline. And I've got the spreadsheet here. And Sandy, Kaiti, would you give us just a minute or two? What do you think the biggest takeaways for our group are about the numbers, if that's okay?
Hi, I'm so sorry that I'm running a little late. The good thing about meetings in person is that you're in person, but the transit time in between is a little rough. So my apologies for being late. I appreciate the introduction. Also, I do want to just say it was really the fantastic outreach of Melissa. So it was a team effort. She and I worked together on getting those numbers together. So I want to just share the appreciation. In terms of some of the takeaways, I would, instead of maybe me going through, since folks have access to it, if there's any questions maybe that I could feel that might be useful, or if just since you guys have met already, I don't want to kind of rush in and say, oh, let me recite some tables and charts for you if it's not useful.
Sure. Sandy, if you don't mind sharing I'll share my screen here. And I just want the group we'll just take a minute sharing the Excel spreadsheet right now. Yes? Yeah, okay. So it looks like the numbers that we're seeing here, if I'm understanding this correctly, we're ranging like the low to mid 100, 200 cases per year coming out of, and this is, just want to confirm, this is the cases coming out of the justice or municipal courts and going to the circuit court, correct?
Essentially, yes, there is also a county court, but that's only a handful of numbers. If I might just, perhaps what might be useful is to go to, I believe it's filings by case type, paren 2 might be particularly useful. And then there you can see the breakdown. If you scroll up, you can see the breakdown per year based upon the civil versus criminal. And then also from the, I'll refer to as like the source court, essentially, if that might be useful, whether it's a justice or a municipal. So if you're looking for more breakdown of data, that might be more useful. And then you can see totals as well.
Okay. Well, thank you for sharing that. Does anyone else have any questions, or did anyone else notice any information that they want to call out for the group about the numbers that we have now?
One thing that leaped out at me is that my understanding is that about 80% of Oregon's population lives in municipal areas, in urban areas that I presume are subject to the various municipal courts, and then only about 20% of the population lives in areas that are subject to justice courts. And so I would have expected a similar imbalance in the number of cases being appealed from municipal court versus district court, but the data show that they're not, well, there, in some years there is fairly substantial difference, but in other years not. So I don't know how to explain that.
Mhm. And Katie, there was a question about whether it's possible for us to determine where these appeals are coming from by court or by county. I guess it would probably, given what Jim is saying, by county might not be specific enough because you could have an urban area which could have multiple municipal courts. So what I imagine the information is somewhere in the database if we wanted to find out more about what particular courts were sending the appeals up.
I don't want to speak on behalf of our data folks, but I can check in on that.
Okay.
So I'll make a note of that if that's something
Okay.
folks are interested in.
Other questions or observations?
I guess I just have a question for folks. Just to give people who have more insight than me, are these numbers large, small, in the middle? How are people interpreting these in terms of how they potentially should inform our design of the statutes as we move forward?
I won't speak first to that. I'll let other people weigh in on it, but I do have some thoughts.
I personally thought they were small in comparison to what I thought they would be. Just knowing the volume that I think are appealed just from Eugene and into Lane. So, and we have, I mean, I'm sure we have more than this, but we have Florence, Eugene, Springfield. And those are just the three that I could think of off the top of my head. And I know the number of appeals that go up from our court. So it seems small, at least in terms of appeals of misdemeanors to municipal court, in my opinion. I actually didn't realize the number of violations that were appealed from municipal court were so, I thought those were pretty substantial in comparison to what I had thought, but I do know there is a large volume of those that go through our court as well. So that's my take on it.
Other thoughts? I also thought it was low. I mean, I think there is a large volume of cases going through. I don't have a sense of the percentage of appeals that come to the Court of Appeals from circuit courts. But to make a comparison, but this did seem low given the number of cases and the number of courts, like Jim was saying at the outset. There's a lot of these municipal courts throughout the state and justice courts, and these numbers seem a little low. Maybe people are very satisfied and don't feel like there's anything to appeal. I don't know, but I thought they were lower than I had expected. Okay, well, if folks are ready, I will stop sharing this screen. Okay. I have too many windows open here. Okay. All right, well,
Now you're sharing something else.
Sharing the
actually.
Westlaw, that's okay. I would like to not share it and just,
I can do it. I can do it for
can
you.
you
If that helps.
unshare that? Yeah. There we go. Now I can see everyone a little bit
There
better
you
on
go.
my screen. Thank you. All right. So the first issue we're going to take up today is the information, the required contents for a notice of appeal. And in the documents that I just basically prepared to walk myself through the existing law and the draft. On the contents of the notice of appeal, I think the most important things to know are for the courts of record, justice or municipal courts of record, the contents of the notices of appeal are the same as they are if you're coming from the circuit court. And of course, the big difference is when you are a court of record or the circuit court, you have a record, and so your notice of appeal is going to go to the Court of Appeals, and it's going to include things like your designation of record, because there is a record, and it's going to include things like a statement of the points that you intend to rely on if you haven't designated the entire record, because what you're doing when you're going from the lower court of record to the Court of Appeals is you're assigning error to a ruling by the lower court. And so the notice requirements for those, notice of appeal requirements for those types of cases do not like translate directly to what we need to have in the notices of appeal from the justice and municipal courts to the circuit courts, because there's not a transcript in most of these cases. You're not assigning error to a particular ruling. You're just proceeding to a de novo proceeding. So we can't just say, how do they do it in courts of record? And we'll do the same thing for our justice and municipal courts that aren't. So we have to think about what we should put in the notices of appeal for these. And on the document, which I can pull up, the first question was whether anyone thought that in the cases that there are in the courts of record where you have to file the same notice of appeal as you would if you were coming out of circuit court, is there any disconnect? Is there any language in the statute that governs appeals from circuit courts to the Court of Appeals that doesn't match justice courts? I didn't think so. That statute's 19.250, which is the one I have up. Sandy, I don't know if you can share that screen again.
Sure. Which I apologize. The one from the document that you sent me.
Or can you go back to sharing my screen? Or I think I can.
You can. Yeah, I can't share your screen, but I
Okay.
can. You should
Here.
still be allowed to.
There we go. Is it sharing a Westlaw screen with you
It
now?
is. Yeah.
Okay. So I will try. This 19.250 governs the notices of appeal from basically circuit courts to the Court of Appeals. It has basic information, the title of the case, names of the parties, all of these things. It seems to fit pretty well with, you could come from a justice court of record or a municipal court of record and do all of these steps. I didn't see any obvious disconnect there. So I think that is probably fine. And Sandy, can you share your screen with the document that I sent yesterday?
I can. Just give me 1 second.
Okay.
Do you want me to take yours off and I can share that?
Yeah.
Yeah, happy to. Just give me 1 sec. I also have many screens, so it's gonna take 1 second.
Yes. So if you are working either with the document set yesterday or our draft bill, we're going to be talking about sections 9. We're going to start with section 9, which talks about the contents of the notice of appeal.
Sandy, was the draft bill sent in an earlier group?
Yeah, the draft bill was. I can get that out. And Melissa, I apologize because that would have
That's
been
okay.
before, but I can get that to you.
Okay, thanks so much.
No problem. And I'm getting mine shared 1 second.
Okay.
There you go.
Great. And Sandy, can you scroll to page 4 of that document? and there's some red text. Perfect. And that's section 9. And so this is the section about the contents of the notice of appeal. And in this document, I've got the bill typed out, and I apologize for typos in advance. And then I've put in the margin some comments, just conversation topics that we might take up today. So section 1 is the title of the cause. In the notice must contain the title of the cause in the justice court. And everybody should keep in mind, like, this bill right now is about justice courts. Jim, and you can explain, like, that's our starting point. We're starting with justice courts with the idea that there will be other provisions on municipal courts, right?
Yes. And actually, I believe section 9 addresses notices of appeal from courts not of record.
Yes, right, because everything of record should be pretty much set because it's linked to the appeals from circuit courts, right? Okay. And so in sub 1 here, the party appealing is known as the appellant and the adverse party as the respondent. There's a typo, but the title of the action is not otherwise changed. That language appears to come, it's consistent with what we already have. In the comment, you'll see it is the same as the current language for civil appeals in justice courts, and it is substantively the same as criminal appeals from justice courts. So I didn't think that there was anything there that jumped out at me. If we move on to sub 2, it says the postal address of each party, or if the party is represented by an attorney, the party's attorney. So that's sub 2. And the one thing I had a question for the group about sub 2 was whether we wanted to require the parties to provide email addresses. That is required in the normal civil appeals statute. And it is required, it's part of the Oregon Rules of Appellate Procedure sample notice of appeal. They have it there. So I don't know, Jim, Jessica, what are your thoughts on whether we should have folks put in email addresses, or what are the thoughts of practitioners? Is that a realistic thing to request?
From my perspective, because the Court of Appeals is located in Salem and most of our litigants live in other parts of the state, email is a very convenient way to keep in touch with the parties. And frankly, with e-filing now, it's the way most parties prefer to deal with the court. What I don't know is what the practice is in circuit courts, whether circuit courts prefer to communicate with parties via email or postal mail.
Okay.
From a drafting perspective, it would be really easy to just take some of the language from 19250 about electronic mail addresses and put it in here.
Okay.
Frankly, with the way circuit court records are automated now, my recollection is that a lot of the notices that circuit courts generate are generated by the court's filing system. And I suspect that's how the circuit court basically corresponds, at least with lawyers. Now, whether they correspond with pro se litigants in the same way, I just don't know what the practice is.
Okay. Other thoughts? Or one thing we could do would be to draft it with email of the request for the email addresses, and when we reach out to the local courts and practitioners, see if they have any reaction to that. One of the other statutes or sample forms says the appellant's email, or interestingly, a statement that the appellant does not have an email address. So you either have to provide an email address or tell the court that you don't have one. Any thoughts on any reasons to not include a request for email? No, okay. So maybe we can add that. The next one, I wanted,
Sorry,
Go
Justice Duncan, this
Yes.
is probably nitpicky, but, and Jessica, you're probably on top of this, but is postal address consistent with other terminology in the ORS, or is that moving to mailing address?
I know.
Postal,
go
oh,
ahead.
sorry, go ahead.
Um, I know I happen to have 19, the civil appeals statute, ORS 19250 up, and they're using postal address there. Jessica?
Yeah, and I know that that is mainly what that specific subsection was derived from, and so the term postal address was used.
It seems ancient, so that's why, that's why I was wondering.
So we can put a question mark there. Jessica, and maybe we could check and see if outside of this area, there's a more current term being used. Or Jessica or Victor, do you have a sense of that from other areas of the ORS?
I'm getting 32 hits for postal address throughout ORS and 546 for mailing address. So I think
Okay.
mailing address is the more common term, and I don't have an objection to changing that if people feel strongly about it.
Okay, great. We can try that. Before we move on, any other thoughts on sub 2 here? Mailing address, we'll add email. Sounds okay. Okay. Sub 3 says that the notice must include an identification of the justice court's order or the judgment from which the appeal is taken. Jessica and Jim, it's my understanding that that is new, but it appears to be new, but it's similar to the ORAP 2.05, and that requires that there be a statement that the appeal is taken from the judgment or some specified part of the judgment. Is that right?
Not only is it in the ORAP, but it's also in ORS 19250 at subsection 1D.
1D.
Because in civil cases
Okay.
coming out of circuit court, appeals can be taken from some pre-judgment orders and from many post-judgment orders. Similarly, in criminal cases, particularly respecting the state can appeal from a number of pre and post-judgment orders.
Right.
I think those requirements translate well to the extent that appeals are taken from justice and municipal courts in misdemeanor cases. It translates less well, I think, to civil and potentially violation cases. But I don't see that it does any harm in the event that in a civil case, someone would try to appeal from, for instance, a post-judgment, an order relating to enforcement of the judgment.
Yeah. Okay. So 3 looked good to me and makes sense. Any other thoughts on 3? Okay. And 4 is new, I think. And it talks about there's a procedure, and John Henry, I think you've mentioned this before. There's a procedure where by statute, a party can request, even in a court that is not a court of record, that there be a recording. And sub 4 says if the appellant wishes to include in the record on appeal a transcript that was prepared pursuant to that statute, the notice should contain a statement of the proceedings that were recorded. Jim and Jessica, do you want to tell us, that seems to be new. It would be unique to justice and municipal courts because it would be a record in a court that's not an official court of record. Would you let us know what you're thinking there? It seems like a good idea, but I'm just wondering about that.
I think this section raises a larger policy question in that under current law with respect to both justice and municipal courts not of record, the appellant is to prepare a quote unquote transcript of proceedings and file that with the circuit court. So the responsibility to put before the circuit court the record of the trial court proceedings is in the hands of a party. That has always bothered me. I think it should be in the hands, and I think it ought to be the responsibility of the clerk of the justice or municipal court to forward the record to the circuit court so that a party doesn't have the opportunity to either insert something in the record that's not there or to take something out of the record that the party wishes wasn't there.
So
having said that, potentially justice and municipal courts would raise a concern that such a change would impose a cost on them because it would require their employees to do work that they're not currently doing.
I do recall that in this statute that talks about a party arranging for a recording, that there can, if there's agreement and only if there's an agreement of the court and the parties, that this recording can become the official record of the proceeding. And so maybe only in circumstances where the recording was the official record of the proceeding, then maybe that would be something that could be designated. So that if it was the official record of the proceeding, then maybe the original of the recording would be stored with the local court, the trial court, and only that version could be passed along. That might protect against the tampering.
I think that would require a change in law. I think that statute that authorizes a party to make a recording puts the responsibility on that party. Or actually, I think the statute's actually silent on what happens to that record.
Yeah.
Presumably, it stays with the person who operated the recording machinery in the courtroom, or who, if there's still stenographers used, stenographers used. But I think the more common situation is when we're just talking about the pleadings and any evidence that was offered and received.
Yeah. So maybe but sub 4 is about this like audio recording, basically, right? A party arranged audio recording.
Well, yes, okay, I see what you're saying. Yeah.
So maybe we back up a step. So there's this procedure where a party can arrange to have their proceeding recorded and then have that recording transcribed. I'm wondering what role passing that transcript along would have, because you're going from your justice or municipal court to the circuit court for a de novo proceeding. So what do people think about the situations where you may have a transcript in this non-court of record? Should we provide that should be passed along to the circuit court that's going to do a de novo proceeding? What do people think?
I think John was going to say something earlier.
Your Honor and members of the group, I testified in the legislature in 2015 session about this bill. And I believe that the application where we're talking about in section 9 applies to justice courts that are not courts of record,
Right.
correct?
Yes.
One of the fears of the justices of the peace, as expressed by their lobbyists and before the legislature, was that this procedure could make the court that's not a court of record to be a court of record. And that is clearly not what the statute says. It says, if all parties agree, in section 3, if all the parties agree, the audio recording or stenographic or other reporting of the proceeding under this section may be used by the parties during the proceeding. And then if all the parties to the proceeding in the court agree, the audio recording or stenographic or other reporting of the proceeding arranged under this section is the official record of the proceeding.
Yeah.
I don't believe that turns it into a court of record.
No, I don't think so. And there's a statute that talks about how you become a court of record, and you can only become a court of record if you're you have the ordinance changed by your county in justice courts or city. And so and then you have to do all this filing. So it won't make them courts of record, but you can, under this statute, arrange for a recording when we're talking about what has to be in the notice of appeal and whether, like, normally you, if you're going from circuit court to court of appeals, you designate the record. Is there any reason we would provide for designation of these recordings, party arranged recordings? That's what I'm wondering what the group's thoughts are.
Your Honor, I think that by including this, it will create confusion.
Mhm.
And having testified with examples before the committees on this, the provision for an audio recording was just by having one of the lawyers pick up a tape recorder
Mhm.
and turn it on. And you could turn that on for the testimony of one witness and none others, et cetera, et cetera, et cetera. So I just think that this section 4 is inapplicable when the justice court is not a court of record. And
Okay.
it will create in the minds of some people and fear in the minds of some others, maybe justices of the peace, that this procedure could, quote, make this into a court of record when the governmental agencies have not done so.
Okay.
And I was thinking an analogy to the situation where a referee hears something and then there's a de novo hearing potentially by a circuit court judge in different statutes. And in Multnomah County anyway, sometimes the audio recording is put in as an exhibit in the de novo proceeding, but it's not something that's automatically.
Okay. Yeah, so if we were to not include sub 4, that would mean this party arranged recording isn't something that's designated part of the appellate record. But when you get to the circuit court and you have your de novo proceeding, if there was some reason like impeachment or something that you wanted to introduce the recording, that would still be an option, but that would be at the litigation stage and not at the like just notice of appeal transfer stage. What do people think about that?
I think that's perfect. I mean, that's what the appellate lawyer could want to do to impeach somebody. Perfect example. It doesn't make it into a court of record, but you can preserve what somebody said in the court below to impeach them in the appellate court, pardon me, in the circuit court when you're trying a case. No problem.
Jim, I know you have it in there, and I don't want to suggest that we take it out without making sure that we have your thoughts on that. and Jessica too.
I am persuaded that it makes more sense to leave it out and leave it to the parties to make such a record, part of the record in the circuit court by motion practice if and when it becomes appropriate.
Okay, okay. All
And
right,
I'd agree with John too. I think if it's truly a de novo matter, things need to be presented de novo, and as opposed to having, the record, which an appellate like judge could look at the record, as opposed to where, and I will say currently right now, the way the court does it is they send the entire file over to the circuit courts, which I'm not entirely sure is what is intended. That includes, random letters from defendants, whatnot. It's just kind of odd ball stuff that gets sent over there is really just the entire file, when I think in reality it's supposed to be that register of actions.
mm-hmm.
But maybe I'm wrong, but it just seems odd that all that stuff gets sent over when it's a de novo matter.
Yeah, and that's and we will, there's separate sections that we'll take up probably at our next meeting about what gets passed along, but that's a good thing for us to keep in mind, because let's say you do have one of these recordings or you do have exhibits, and if the idea, like you're saying, Melissa, is it's supposed to be de novo, maybe that next court shouldn't even get the exhibits if they're part of simply because they are part of the justice court's file. Okay.
Can I just
yeah.
add something quickly? And I don't have any strong thoughts. It's really Jim who deserves the credit of making some of these, coming up with these policy questions and making these connections between the statutes. But it sounds like subsection 4 should be removed. And I'm just wondering, do we need to address at all how, somewhere in this draft, how these transcripts or audio recordings could be used during the appeal? Or is that just something we're going to have to deal with at a later date?
So just as we've been talking, one of the thoughts I had was so right now we're just kind of coming to our preparing the draft, but when we get further along and we're presenting the draft to the full commission and then later to the legislature, I envision that it will be accompanied with a commentary. And so maybe, at least when we get to the commission, we could say this section 9 about the contents of the notice of appeal had this provision for including some, sometimes in legislative history, it'll say, well, very well, it'll say it used to say this and this was removed because the group thought it was unnecessary. And maybe in commentary, we could say something along the lines of, should a party seek to use that recording, it would be perhaps as an exhibit. I don't know. What do people think?
I've got an idea as a trial lawyer and an appellate lawyer. I believe that issue shouldn't even be addressed, because the admissibility of evidence, for instance, for impeachment, is just a matter of ordinary evidence law that's adequately covered by the Oregon Evidence Code and case law.
Okay.
Just again, and analogizing to the referee situation in Multnomah County, sometimes parties choose to adopt what already happened. If witnesses already testified and they don't want to have them come back and testify again, they may just use that recording and say, but legally this was wrongly decided, but we're still using the same evidence. So it could be used, with everybody's consent.
Okay. And do you think both John and Krista, like, people would understand that without us having to address it in the commentary, in a commentary to any proposed bill? I see some nodding.
I think that would be an interesting thing to bring to the larger group, perhaps, but I mean, I don't think it needs to be addressed necessarily, because people will figure out how they want to use it.
Yeah, if they have something they want to get into court, they'll find a way. Okay. But we could start, so we have layers to go. We have our small drafting group. We have our larger group on municipal and justice appeals. and then we have the full commission, and then we have the legislature, so we can decide what to present to the different levels and get feedback from even more folks. Okay, so that gives us some information about sub 4. And let's go to, does anybody else have any other thoughts on section 9?
Sorry, I have a quick
Yeah.
thing. It does, section 9 does include subsection 5, the signature of the appellant or attorney for the appellant. I feel like that's not particularly controversial, but I just wanted to point that out.
Oh, thank you. So there's a sub 5 there that I didn't successfully paste over.
Yes.
Okay, thank you. That's great, because that takes care of my question about whether we needed to put the signature there, because we have it in section 19. Great, thank you. So if this notice of appeal in section 9 covers most notices of appeal, and section 9 is specific to, I think it's the criminal misdemeanors and violations, right? Section 19. Yeah, violation and misdemeanor cases. So is the thinking in section 19, Jim and Jessica? There we go. So that requires the signature, and section 19 is about violation and misdemeanor cases. And so there we are specifying that we need the signature of the district attorney or the attorney general in those types of cases, or the city attorney if it's the county case. So, and I had a question on the side just about whether every time that you have a case that's litigated in the local court in the name of the county, is it going to be the city attorney who's litigating that?
Well, if the case is a misdemeanor, technically the state can choose to take over the litigation, because it's actually state versus instead of city versus. I would say in most appeals out of municipal court that I've seen, they always come to us as city of so-and-so versus defendant, even if it's a misdemeanor that's being charged. We then at the appellate level change it to state of Oregon, because Oregon is the real party in interest respecting a misdemeanor. The city or the county is the real party in interest with respect to a violation of a city or county ordinance.
Yeah.
Speaking of a typo in section 19 sub 3, when we're talking, this addresses appeals taken from justice court, so
Right.
the county attorney should be signing the notice of appeal.
Okay.
not the city
Okay.
attorney.
Okay.
And that, but I thought it was an interesting question that has been posed here. Do county attorneys defend these appeals, or whether if the county takes the appeal? Well, certainly if the county takes the appeal, I assume it's through the county. Well, I guess it'd be to the district attorney, and I assume the district attorney would defend with respect to a defendant's appeal.
Yeah, it seems, oh, John.
I've practiced in justice courts throughout the state, and I have never seen a city attorney represent anybody. I've never seen a county attorney represent the county or the state, whoever is the plaintiff in a violation or a criminal case. And for instance, in Clackamas County, we have, of course, the district attorney for Clackamas County who prosecutes criminal cases. And then we have a county attorney that handles only civil proceedings. I've never seen a county attorney appear in a justice court or on an appeal in circuit court from a justice court.
Yeah, I think the goal here and in some of the existing statutes is we're just trying to figure out who in a criminal misdemeanor or violation case is going to be representing the government entity. And it can be complicated, although it looks like it's often the district attorney. In municipal cases, it could be the civil attorney. It sounds like in justice courts, it's not going to be, could be, but is usually not a county attorney. Any thoughts on the best way? Is there a generic way to describe these actors so that there's not confusion about who needs to sign these, or so that we don't say it has to be the district attorney if the district attorney hasn't been involved in the case?
Our catch-all term for like government bodies is public body. We could say something like, when the appeal is taken in the name of a public body, the attorney representing the public body. That's very broad, but it would cover anyone.
And my fear is that for a self-represented party, they'd have no idea what that means.
Right. So this says when the appeal is taken in the name of the state. How does it work when these, is it clear at the local level which government entity, whether it's the district attorney acting for, is it clear in the title of the case at the local level which government entity is bringing the prosecution? Is its caption of the case going to be City of Eugene, or is it going to be State of Oregon in a misdemeanor violation, for example? John, yeah.
We always say City of Eugene. When it goes over to Lane County, it still says City of Eugene. I think we still do that even with violations of the state statutes. So we have the vehicle code adopted and the Eugene code. And so even if it's like I think the current statutes say that if we're doing it, if it's an ORS that's being charged, we're actually supposed to do it in the name of the state.
Okay.
But I don't think we're actually following that in practice. I think we still say City of Eugene, and we represent the city in pursuing that in the circuit court. If it's a violation of just Eugene Municipal Code, we say City of Eugene still. And we sign it as a city prosecutor's office.
So it sounds like we couldn't just say if in a case where the caption at the local court is the city, you serve, the person who must sign the notice is the city attorney. Or we can just say if it's the caption is state, serve it on the DA, or have the DA sign it. Caption is city, have the city attorney sign it. It sounds like it might not be that easy.
I think the statutes are clear that the district attorney with respect to a justice court and a city attorney respecting a municipal court has the authority to represent the state in the trial court. And so that's why it makes sense for the notices of appeal to be either signed by or served on the DA respecting a justice court and a city attorney respecting a municipal court, even though the real party and interest in misdemeanor cases may be the state. I recall one instance in the Court of Appeals. Well, actually, I think in virtually all instances, the AG's office takes over representation, at least in misdemeanor cases. But that's just more of a function of an agreement between DA's office and city attorney's office. It's simply easier for the AG's office, since they're right there in Salem, to handle it.
Mhm. Yeah, John.
Your Honor, I really hesitate to speak on behalf of the prosecution, but now that I've retired from the active practice of law, I think I feel a little more comfortable in saying this on their behalf. They would really, really object to anything that would require them to increase their workload. Frequently in justice courts, the prosecution of many cases, violation cases, traffic violations, are handled by the police officers themselves. And if somebody took an appeal from a justice court conviction in a violation case, the district attorney would really, really not want to be bothered with that work.
Yeah.
And I have never seen, well, that's what I'm going to say, is that
Yeah.
the prosecutors would really object. If they got a notice of appeal, they would think, now we've got to go to circuit court and, prosecute this case that we didn't have anything to do with in the justice court. I don't think they would like that.
Yeah, and our challenge is, especially with the service, but also in the notice and who signs it, like, we have to make it clear who's, if you're being prosecuted for a misdemeanor or violation, the statutes, we should make it clear to the defendant who wants to appeal, like who gets served with this notice. And I don't know where we are on, if there's a general rule we can create for who should get these notices.
Well, I'd like to weigh in on this, Jim, excuse me just a second. Frequently, as I said, for instance, in violation cases, the police officer is the person who actually prosecutes the case in justice court.
Yeah.
If there's an appeal and you want to name the police officer who prosecuted the case, then you get into the knotty problem, KNOTTY, of Chapter 9, unauthorized practice of law. And in the, for instance, in the implied consent arena, police officers are, by statute, are given relief from any accusations that they've been practicing law, so they can make arguments based upon the record and application of statutes, specifically referring to Chapter 9. So this, to me, is a knotty problem about how to, and then in criminal cases, I don't know whether police officers represent the interests of the state when there's no prosecutor in justice court. I don't know. I've never seen it.
I would point out, respecting courts of record, the current statutory scheme requires service of the notice of appeal on the DA. The district attorney can then decide whether to handle the appeal, or as I said, far more commonly, they simply pass it along to the Attorney General's office. So I don't think it would be a substantial increase in their workload to decide, for instance, in an appeal from justice to circuit court, to just go ahead and allow the police officer to handle it again, or choose to appear on behalf of the state or the county if the particular case warrants it.
Melissa, yeah. Go ahead, Jim.
The statute doesn't require the DA to do anything. It just requires that the government body whose prosecution is being appealed have noticed that the appeal is taken, and then it's up to them to decide what they wish to do.
So maybe if Melissa, you can walk me through it. So if you have a case that's prosecuted by the city of Eugene and you're there and the defendant wants to appeal, we'll do the defendant scenario first because that's maybe more common. The defendant would file a notice, and then if we're talking about service, do you know where that notice would go for the prosecution entity? Does that go to you? Does it
Comes to
go
us.
to the DA?
It comes to us.
It comes to you. And does that work?
Yes.
Okay, because
We-
for you, your office will be litigating it. Question, will your office be litigating it in the Lane
Yes.
County Court? Okay,
And that makes, I mean, it certainly raises a question of whether or not other municipalities do the same thing.
uh-huh,
I don't know that there's any written rule that specifically says, you know, the city must take it or the DA must take it. And so it certainly, I think, would be, maybe this is something we may need to table and get feelers out for other municipalities and what they end up doing. Because I don't want to say just because we do it in Eugene that that's, you know,
right.
the rule. So
I think
What-
yeah, go ahead, Jim.
Wasn't at the last meeting, and I forget who mentioned this, whether it was a representative of a justice court or a municipal court, but the person said that they actually have form notices of
Yep.
appeal available at the counter, and typically the defendant walks out of the hearing, goes to the clerk's desk, fills the form out. It's a multiple copy form. The clerk's office tears out the copies, staples them, and puts one copy in the DA's box, and takes the original as having been filed. If that happens, is a wonderful thing. That makes it easy.
Yeah.
But- But I don't think we can assume that that will happen in every single justice and municipal court.
you're right, Jim, and that's out here in Eugene.
Yeah. John, and then I just want to mark the time. We're at 2 and we had scheduled this for a 1-hour meeting. So just want to let folks know we're keeping an eye on that.
I would recommend that this particular issue be deferred to our next meeting, and in the hope that justice of the Washington County Justice Court can
Mhm.
enlighten us on some of the practicalities.
Okay,
Like- yeah.
I think that's great. And I think that actually, since we're at time, that's a good place for us to end. And just for people to keep thinking, our goal is to, what can we do to make it as clear as possible for people to know who to serve or who needs to sign? And we understand we have this difficulty where the caption might say something about it being prosecuted by the state or by the city, and then you might have a state representative or you might have a city representative. So it's 2 o'clock. We still have, and I guess we could go ahead and schedule our next meeting if that works for people.
Yeah, that's fine.
If people look at their calendars, and we can take up our, we've already started talking about the service of the notice of appeal, so we can continue with this. Calendars. I know we're into the busy summer season and a lot of people are away. We're setting these meetings about every 3 weeks. How does the 20th or 27th work for people of July?
20th, let's see.
Oh, the 27th doesn't work.
The 27th I cannot do because that's one of the bar exam days that I have to be on duty. The 20th can.
Okay. And actually, I spoke too soon. I can't do the 27th. 20th, 21st.
21st would be preferable for me because I know 20th that's a trial day for me.
Okay. 21st for other folks.
That works.
Yeah, works for me.
We could also go out further if people would like. August is pretty hard to schedule in, maybe not.
Are you thinking the same time?
Yeah, well, I think we did afternoon because Krista, there was a conflict today for maybe you and Judge Gill is morning, so we're flexible. Okay, Katie.
I'm available on the 21st. I can do the same time that we have for today. In the morning, it's a little tight. I
Okay.
do have a hard X out from 11 to 12 though.
Okay. Other folks have a preference if we go on the 21st for a time of day? Hearing none, maybe we'll just stick with 1 o'clock.
Well, I will say that I have a preference for the mornings, but
Okay.
that's, I'm certainly willing and able to meet in the afternoon too.
Katie, can we squeeze in at 9?
I can make 9 o'clock work. Yeah.
Johnny, I saw you, but I didn't hear you. Does 9 on the 21st work?
Not for me, I have a conflict.
Okay.
Wait a minute. On the 21st, I could do it at 9. I'm sorry, apologize.
Okay. All right. Does
So Justice Duncan, should I set it for the 21st at 9?
that work for folks? Okay.
Great, I'll send that out this afternoon.
Okay. Thank you, everyone. I think we are